All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in Vista Verde Homeowners Association v. Maricopa County et al. Versus Maricopa County. Our case number 1CA-TX140014. Both sides have been allocated 20 minutes for oral argument. If the appellants desire to reserve any time for rebuttal, you may do so, and the clock on the podium will indicate how much time you have left, including your rebuttal time, as you know. So if it shows 5 minutes, you've got 5 minutes, including your rebuttal time. You have to manage your own time. To assist you, you should be aware that we have read the briefs, looked at pertinent portions of the record in the cases, conference this matter, so you can tailor your argument knowing that we have a fair understanding of the facts and the issues in the law. While you've been each allocated 20 minutes for oral argument, there's no requirement that you use it. If you're done, we don't have any further questions, you feel free to sit down. Finally, you should be aware that we are recording these proceedings, both audio and video recording. So when you step up to the podium, please first state your name and who you represent. Understand that you're on camera, and that, as I understand it, they can look at the videos on YouTube within a couple of days, if you ever wanted to watch it. So with that, counsel for appellant.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. I'm here with Bart Wilhoit. We're representing Vista Verde Homeowners Association and the owners, who are also listed in the caption of the property at issue in this case. May it please the Court, I will try to save about 5 minutes of my own time for rebuttal if I need that much, but we'll see how this goes. The issues before you in this case, really the principal issue, is whether the tax court committed reversible error in determining that my client, Vista Verde, did not have the right to pursue an error correction claim to correct a mistake in the way its common area property was valued for tax purposes and classified by the assessor under the property use codes. Alternatively, there is a secondary issue which you only need reach if you don't resolve the first in my client's favor, which is whether the tax court erred in ruling that we were not eligible for Rule 56F relief, and specifically that we were not entitled to see the work file that the assessor maintains for every property that's valued, and which was not produced in this case despite requests for production, a motion to compel, and the fact that it was disclosed at least 5 times in the county's own disclosure statement and listed as a trial exhibit. And finally, obviously, if we prevail, it's our position that Vista Verde should recover its attorney's fees incurred in this appeal as well as fees incurred below. And we believe that the county's legal position in this case is so frivolous that fees are appropriate under 12349. With respect...
Counsel?
Sure.
Maybe I misunderstood, but was there also an issue of whether the property qualified as a statutory common area in 2009? Is that really an issue on the appeal?
That is not an issue on appeal, and in fact, even in the trial court, we conceded that the Homeowners Association had not taken title and did not take title till July of 2010.
So we don't need to address that?
You don't need to address that issue. It is interesting, however, that the county, in putting it into the property use code system, could have placed it in a class for qualifying common areas, which was an O2-1 classification, or they could have placed it, or should have placed it, I think correctly, in an O2-2 classification, because at the time of the assessments in each tax year, the property had not been conveyed. So the taxpayer filed an error correction claim, and at the first level of the administrative appeal, the assessor agreed, yeah, you're right, it's a common area. we're going to change it for tax year 2011. The valuation date for that year is 1/1/10. And again, the conveyance hadn't occurred till July of 10, so even on that date it wasn't eligible, but they granted it. Then we go to the Board of Equalization on an appeal from that determination, and at that administrative appeal, the county says, okay, we'll give it to you for 10.
So 10 and 11's taken care of.
10 and 11's taken
And
care
they
of.
could have
So
said that for 9 too, but they didn't.
they could have, and frankly, I think they should have, because the purpose of the error correction statute, as this court has recently interpreted it a few times, and as the Supreme Court has interpreted it, is it's a remedial statute. It's designed to correct errors when everybody agrees there's a mistake. In this case, we have the unusual proposition that the county is basically saying, and they actually said this in their answer brief, we should be grateful that they gave us 2 years that we weren't eligible for. That is not consistent with the policy underlying the error correction statutes. It isn't to say, oh, well, gee, the largesse of the government in giving me 2 years when I wasn't eligible for any, but they're going to withhold the third and say, that's as far as we're willing to go. With all due respect, what the county should be doing is doing its job. And the statutes say it is the duty of the assessor. He shall, this is mandatory, 42-15-054B. The assessor shall make such investigation as is necessary to ensure that all property is properly listed on the tax roll. That's his duty. They want to shift that duty to us, and they tried to do that below by saying, well, you certainly knew what your classification was, and you knew, well, we didn't know. This was a large subdivision that had a lot of lots. These are 31 of those lots that were designated as tracts in the subdivision plat. They were recorded as such. They were common areas for flood drainage, for roads, for landscape areas. That's what these properties were, and they were specifically restricted from being used as building lots. Yet the assessor mistakenly, and I understand assessors make mistakes. Maricopa County is the largest single taxing jurisdiction in the United States in terms of the number of parcels they have to value every year. It is. They have an incredible burden placed on them, which is why we have an error correction statute, because if we find mistakes, we ought to sit down and agree and fix them. And when it was brought to their attention, they said, you're right, they're common areas. We'll change them to the common area value that we use in our office, which is $500 per parcel.
Well, counsel, they didn't pick that $500 out of thin air. They're just.
Yes, they did.
That's the statute.
They actually did pick it out of thin air, and I'll tell you.
You're saying they didn't follow the statute?
No, I'm saying they did follow the statute. They used the 500 because they don't know what else to put them on at, because they have a de minimis value. The rec centers case, the Supreme Court dealt with an issue of a restriction on use, and the Supreme Court said you have to take that into account in valuing property. If you want to know the backstory as to how the 500 came about, it's because that's the minimum amount they can bill on a cost-effective basis. If anything below that, it costs them more to send out a bill than it does the tax they collect. So they've come up with $500, and they use it in a wide variety of contexts, not just for common areas. They use it for a whole bunch of things. 500 is the minimum value they use in their office.
Understood. One thing I think would help me, and perhaps the other judges, is let's make sure we're all clear then on the claims that were filed by the taxpayer in the tax court, and how what claims still exist. I understand.
Tax year
correct me if
09
I'm wrong.
only.
There's one only now. Well, there's one claim now, and that's based upon the actual use, correct?
Correct.
But below, I mean, wouldn't you agree with me that the complaint could have been framed more clearly in the claim you were making? Because it's not clear. The main claim seems to be the statutory common area claim, saying this fits the statute for a common area. We are therefore entitled to the $500 full cash value per parcel. Then you said in the complaint, the taxpayer alleged, in addition, there are other statutes that are applicable here.
We made both claims. They're alternative claims. But you're allowed to plead in the alternative.
I understand. But then the tax court, reads that narrowly and denies your motion to compel and says, look, there's only one claim stated here. It's a statutory common area claim.
The tax court was fully briefed on the issue, and we made the argument below to the tax court that in fact...
You didn't seek to amend the complaint to make it real clear.
We didn't need to. The complaint alleged that current use controls. There were alternative theories pled here. And by the way, although I conceded for purposes of Judge Kessler's question a moment ago that we're not pursuing the statutory provision here because there was no conveyance to the HOA. That is a technicality. And in fact, courts in error correction cases, including the Hormel case and other cases that have been decided by this court, have ruled that those kinds of technical noncompliance issues don't change the underlying right to be treated as the statutes contemplate. If this is a common area, and they are, and the only thing missing is a conveyance to the HOA, we could legitimately and in good faith argue, as we did below, that in fact the non-filing of that paperwork, the non-transfer to the HOA, when the property is already restricted in use, it's designated as a common area, it's been platted as a common area, it can't be sold for any other use, all of that controls its use. Therefore, it is a common area. It may not be a common area under the strict reading of, oh, well, you didn't file this piece of paper. That was true in Hormel as well. In Hormel, the issue was historic classification of property, whether the Wrigley Mansion was a historic property. It was undisputed that it was. It was undisputed that it was on the National Register of Historic Places. It was undisputed that it qualified in every respect for classification as historic property. They hadn't filed the piece of paper with the assessor. And this court upheld the error correction claim in that case, which was a mandamus claim, demanding that they pay the refund that the client was owed.
But again, I just want to make it clear, you're not pursuing.
I am not.
Okay.
I am
Let's
not.
go to the rest of it.
And I believe we made the alternative argument below, and I think we were permitted to. And under notice pleading, this is more than satisfactory allegation. And the oral argument was, Your Honor, even if we've alleged that its current use is as a common area, and there is a classification in the PUC code for this kind of non-qualifying common area. So why were we not put there? And if the assessor had adopted a policy for non-qualifying common areas that they'll be valued at $1,000 per parcel, we wouldn't have had any basis to object to that. They didn't do that. They don't have such a policy. In fact, their only policy is to treat common areas at $500. So the simple fact is it's sort of a distinction without a difference, I suppose, in one sense. What we were alleging was there's an error here. The error is you mistakenly valued these lots at $12.5 million, the same numbers you put on the building lots that could be sold for houses. And you assessed my client over $100,000 or nearly $100,000 in taxes in 2009 based on that determination. That's wrong. Everybody knows it's wrong. You know it's wrong. And therefore, it should be fixed. Now, whether you should fix it because it technically meets the requirements of 42-14-1302 except for the conveyance to the HOA, or whether you should fix it because the current use controls and must control under our law, I don't really care. At the end of the day, what I want is I want the mistake fixed. This is a remedial statute. You're supposed to be agreeing when you agree that the facts are beyond dispute, and the facts here are beyond dispute. Now, the tax court's primary reasoning below was based on a rationale that this court has since rejected. I realize it's an unpublished decision in the Levy case. We've cited it. We've discussed it. You're certainly familiar with it. It came out in May of this year. Levy is factually directly analogous to this case in that what you had was a situation where the argument that was made against the right to an error correction was, well, you certainly knew or should have known about your classification, and therefore you could have appealed it timely, and you didn't, and therefore you're now barred. This court said, no, that's not the way Levy should be interpreted. The court has also more recently, last week, in the Phoenix Cement case, another memorandum decision that was issued on the error correction statute. I think, Judge Gould, you wrote the opinion.
Excellent.
It is an excellent decision.
It's so well written.
It is.
Isn't it?
But it reaffirms the same finding in Levy that this was a clarification. The legislative clarification of 42-16-255 is that. So I don't think I need to say a lot more than that. I want to spend just a second and talk very briefly about the lack of production of the county's work or county's file for the subject properties. I've been doing this for 35 years in December, and during the majority of that time I've been litigating property tax cases. This is the first time ever that the county has not voluntarily turned over its file for the subject property, let alone given it when we asked for it.
Counsel, given that you didn't receive the file, understood you didn't receive the file, didn't receive the numerous or the several things that you had asked for, how would we, let's say that we agree with you that the assessor made a mistake here, or allegedly made a mistake, or you've at least stated the claim sufficient to move forward. Why, if there's unresolved things, you don't know what happened, why would we go ahead and enter summary judgment in your favor on appeal? Now, it seems like you're asking us to do that, to flip it.
I am. In the first instance.
Well, how could we do, what would be the full cash value?
Would be exactly what the assessor has already determined the full cash value is for all of these years. They've already set it at $500 per parcel in 2010, 2011, which have valuation dates that precede the conveyance to the HOA. So for a uniform...
Why shouldn't they have the opportunity to at least provide you the file? Why shouldn't they have the opportunity to make an argument that it should be something different than the same as 2010, 11, and 12?
Well, I'd love to hear that argument under the uniformity clause of the Arizona Constitution, because under Article 9, Section 1 of the Constitution, they're required to uniformly value and assess all property in the state. I will love to hear the argument that somebody wants to posit. The reason I asked for that relief is because no argument was raised below by the assessor whatsoever that the $500 was incorrect. In fact, there's an admission against interest in setting the values for the same parcels for tax years 10 and 11 at $500 per parcel. There's an admission by conduct. They have basically conceded that their policy, their uniform treatment, is to treat common areas at $500. That's what they did for tax years 10 and 11, even though the valuation dates for both of those years, January 1 of 09 and January 1 of 10, predate the conveyance to the HOA. That's the reason I asked for that relief. Now, if you don't agree with that, then it should be remanded and there should be a determination. I agree with you.
Go back a little bit, and maybe you're not aware. I believe, wasn't this statute, this common area statute, adopted in the 90s and the mid-90s, perhaps? I
regret to inform the court that I wrote the first draft of this statute before Ledge Council got a hold of it, but that was in 1994.
Okay,
Senate Bill 1362.
What was the practice before then? What happened before then?
There were a series
the
of...
assessor had to evaluate common areas. There's many common areas that have existed before that.
We didn't have a common area statute in those days. We always had the practice of valuing common areas at a de minimis value. That's always been the practice. Statute came much later, in response, interestingly, to litigation. But the question about error corrections is the error correction statutes, you go back and look at the Ledge history of it, were written to consolidate about 5 or 6 different places in the statutes that you could fix errors. If you want to read more about that, read the Telco case, the Arizona Telco Credit Union case, which is a Division II decision that involved a classification of property that was misclassified, and the correction claim there was brought under ARS 11506. All of those statutes were subsumed in the new error correction statute, if you read the legislative history. I'll save what remaining time I have unless you have another pressing question.
So it's your position that if we don't grant direct summary judgment in your client's favor, then we also need to address the protective order?
Absolutely. I think it's unavoidable because we're going to have to go on remand. So,
okay.
Thank you.
Thank you.
Morning, Your Honors. Peter Muthig, appearing for the county in this matter. We've heard a lot this morning about use codes, and at the beginning of counsel's oral argument, it sounded like we were almost going to brush over what the county feels is the real issue in this case, and I'm glad we finally came back around. And also, Judge Brown, I'd like to thank you for beginning to make the argument that was my initial argument in this case, which is that you have to look at the allegations. You have to look at what Vista Verde has alleged. And for them to say there's something more there than the simple allegation that the court relied on, it's just not there for the reading. They're talking about errors arising from the fact that subject property qualifies as residential common area and should have been identified as such pursuant to statute. That's what they allege. Beyond that, what they allege is what the other statutes require, and they say, well, that's our allegation that they should have valued it according to current use and apply different use codes. But that's like saying if a tort claimant comes and says every homeowner should keep their home and property safe so no one falls down, and they forget to allege, I came in and fell down, therefore I have damages. So if you look at what they have indeed alleged, that's the whole issue in the case.
Then you would just file a motion to dismiss, saying you failed to state a claim.
Excuse me?
In the case where someone comes in and says, every homeowner should keep their home safe, and doesn't allege that this homeowner didn't and I fell down and hurt myself, what you'd do is you'd make a motion to dismiss and say, you failed to state a claim. You file a motion for summary judgment,
Agreed.
okay? So
But we needed-
it's not like you weren't on notice, right, of what the issue
Right,
was.
and the analogy suffers from that, but the reason we filed a summary judgment motion is because we did have some facts that were disclosed, and those facts were necessary in light of what the law required in order to bring the motion. In order to bring those facts before the court, we had to style it as a summary judgment motion. But the fact, it occurred very early in the process, which is exactly why, without getting ahead of myself, the county didn't feel it was necessary to do any discovery at all until we had this issue heard. Now,
Let's go back to the court's tax, and correct me if I'm wrong, but I recall that the tax court, sua sponte, sort of evaluated the complaint and said, I am construing this complaint narrowly. I mean, it only raises one claim. That was not argued by the county in response to the motion to compel, was it? I believe that the court raised that sua sponte. Then the county followed up with that and said, look, Judge Fink has already ruled this. He's said this is what the complaint means.
Correct. Well, our motion was based on the fact that we were going to bring a summary judgment motion. We felt it was dispositive since we had a statute and we had facts that said the statute wasn't complied with. Part of that was based on the allegations, as only it could have been, because the allegations said that it was based on statute. And if that's the only thing you're alleging, that's what our motion is going to be based on. But it's true that when the judge ruled, he made it more clear that that's why he wasn't allowing discovery to go forward.
Understood, but in follow-up to Judge Kessler's comment, I mean, I think the county was well aware through the disclosure statement and the arguments that the taxpayer, right or wrong, continued to make, that they were continuing to assert sort of the two-pronged approach. Yes, it should be qualified under the statutory common area statute, but there's also, it should be evaluated but based upon its use.
I beg to
Do
disagree.
you disagree that that's in their disclosure statement?
I do.
Okay.
I do. I disagree because what's in there is, again, I guess the best way to explain it is when I looked at the complaint, when my client looked at the complaint, we saw statutory violation, error based on they should have been given this.
So you're in essence arguing not only the disclosure statement, but on the motion for summary judgment, all the briefing on the motion for summary judgment, the issue outside of the statutory common area issue
Correct.
was never raised.
I'm not sure I understand. It was certainly raised in the summary judgment briefing.
Other than that, no, I'm saying other than that, that's the only issue that was raised in all the briefing on the motion for summary judgment. Is that what you're saying?
By the time we got to the motion for summary judgment, by the time they responded and filed their cross motion, that's when the county first saw this detailed description of use codes and current usage and so forth.
Right. So it was at least clear at that point that even if, arguably, even if the complaint may not have clearly set it forth, by the time the summary judgment motions were filed, the county was aware that this was being argued.
Right.
And if it, normally in that kind of case, if the judge said, well, gee, I don't know if that's been alleged, you give the person a chance to amend the complaint.
Okay, but the timing here I think is important because Judge Fink ruled, we filed our summary judgment motion concurrently with our motion for protective order. Judge Fink ruled on that motion, where he included that language that you referenced, Judge Brown, before they filed their response. So by the time they had filed their response, that first aspect of the decision-making process was already over. Mm-hmm. So then the county took that and said, okay, we need to respond to this argument, this use code argument, even though we were going based on the judge, sort of like a law of the case argument. He deemed that this was all that was alleged. We agreed, and so we responded to the use code argument as best we could at the time, but the primary argument was always, look, there's a statute, you didn't comply with it, Therefore, we didn't make an error in tax year 2009.
Understood, but I mean, but clearly you'll agree that in the summary judgment pleadings, that's when the taxpayer really started to assert use codes and went off on that direction much more than the statutory original.
Well,
claim. Yeah.
we think, I mean, it was good that Judge Fink ruled the way he did to clarify what was in the complaint, but we think bringing up the use code is sort of a way of getting past the losing argument that says the statute says you have to comply this way, and we didn't do it for that year.
What has to be? Let's go back to the complaint, I guess, for a minute. Then, what has to be in a complaint when you're challenging an order of the board, a determination of the board by special action? What is the nature of the complaint supposed to be? Is there guidance? I mean, can you just file a special action complaint that says I challenge the ruling of the board? It was erroneous.
Right, but the ruling of the board also was based on the fact that the statute wasn't complied with. Everything keeps coming back to that simple issue.
So you're saying the taxpayer never raised these issues to the board?
I wasn't at the hearing. I've read the transcript. I read one transcript. I never heard that issue raised. So again, as far as what you have to allege, I think if you're bringing an error correction claim, you have to allege the error, which they do in sentence 1 of paragraph 4. The second sentence talks about what the statutes require, but it never says, based on those statutes, you also erroneously did X, Y, and Z. It's just not in there.
You don't think that's in there?
I don't.
You have no notice of that?
From the complaint?
You don't think you had notice of that in the complaint?
No, particularly in view of the fact that the first sentence is so clear. You didn't give us common area statute based on this, status based on this statute, right? The statute's the exclusive method for giving that status and giving that valuation.
Then what's the purpose of the second sentence then? What's the purpose of the moreover? It says, moreover, the subject property must be properly valued in accordance with those sections. If the sole claim is included in sentence 1, then there is no need for the second sentence.
Right. I mean, I'd have to agree with that, other than I thought it supplemented the first sentence.
But it wouldn't be a supplement, because it would be the end of the inquiry. Either it does or does not fit within the statutory parameters under the first sentence.
Right. I mean, again, our readings are different.
So I'm wondering. My view is that there is an argument to be made. There's a reasonable reading that there was a second claim stated, but I understand. I understand
okay,
your position.
and it's fine.
Yeah.
And I plan to address the second claim. I'm not just going to say we're going to rely on our first defense. In order to get into that, you have to understand what we're dealing with here. Okay, common area is part of a larger subdivision development. Now, when the assessor first values this type of land, it's raw land. It's a lot. They call it a dirt lot, right? Everything gets the same value per square foot. My understanding is that once the property gets developed, infrastructure is put in place, the house is built, the lots get sold, and so forth, the property values go up. But the raw land value, which was the initial value, which is the lowest value you get, that's what stays with the common area. So in other words, they're acknowledging, right, that there's this, in the plat map, there's this common area. It gets valued as though it was raw land, and that's market value. And the current use is as a piece of land waiting to be developed, right? So if you were going to sell the whole thing, that would be its market value at that point in time.
For how long? I mean,
until the homeowners association statute is complied with.
Okay, no, I thought we had transitioned away from the statute. Let's assume that there's no statute. There's no statute. How does the assessor value common area property? Because there's homeowners associations that would not qualify today. I mean, that would not qualify. They could still have a common area where there's a little park. That doesn't necessarily mean they're going to fit the statute. How would the assessor value that little piece of property that has a swing set on it?
I guess I don't know how to answer that, because we're not functioning in the absence, at least as long as I've been.
Well, these 31, not in the absence, but we are here, though. We're functioning in the absence, right? We're functioning in the absence of the statute, 31 pieces of property, drainage, I don't know, green belts, hiking trails, whatever they're intended to be. I don't know what they are now or what they were back then. But looking at the plat map, if they're stated as common area, how would the assessor value those just as dirt? I mean,
Well, I guess without knowing more and assuming there's no statute in place and that the lowest value that all of the land is given is when it's first valued, when it's just a dirt lot, then I would assume that value would stay with it unless somebody, lobbied to change the law or do something to get a better value for it.
But there would need to be your position. There would need to be some opinions on that. Wouldn't there need to be some research, some comps or whatever to establish the value of what that dirt's worth?
Well, sure. I'm sure that when the assessor is looking at the lot, they're looking at what other lots of the same size in the same area. There's many calculations that go into it, but I think the point is that when it starts off, it's one value, and that value doesn't increase. The point, I guess, is what use code would you apply to that? The use code is it's a statutory use code. You have a non-statutory use code. I guess one example of if you wanted to use the non-statutory use code is that, let's say the developer had submitted paperwork, applied for the HOA designation, there was a mistake. The county could then possibly assign that use code saying, okay, common area but not qualified statutorily. But if you go back to the use code they applied, which is 0013, that applies to all the land of the subdivision at the beginning. That's the designation they gave it. That's what the value was based on. So I'm just trying to address the argument that it wasn't valued according to current use or market value, but it was.
So let me make sure I understand this. So your argument that before this entire residential area is developed, you have one basic, everything's assessed like they're marketable pieces of property.
Not
Uniformly.
individually necessarily, as part of the larger unit.
So the entire unit is
What would
assessed
become the
as-
subdivision?
it was assessed as if it were marketable property.
Sure.
And then after it gets developed, and there are areas designated as common areas, not qualified under the statute, but they're designated as common areas, the assessor has no duty to go and look at those and say, oh, gee, these have been designated as common areas, and they're not going to be sold. They have a lower use. You're saying the assessor has no duty to investigate that?
Well, you're talking about a duty to take the baseline value and lower it even further. But there's a provision for doing that in the statute. The assessor only functions within,
Right.
I don't know what happened before that statute was passed, and I'm afraid I can't answer
Okay.
that question, but they're going from a baseline value, and if the developer, whoever owns, wants the statutory value, then they have to comply with the statutes. Those are really the two. I don't know that there's any other duty to look at it and say, well, it must be worth something different.
So, but why can't then these taxpayer, so you're saying the taxpayer had a duty to inform the assessor. Wait a second. You've wrongfully, or you've erroneously done this. Because
It's much more than that. The taxpayer has a duty to make sure the homeowners association is formed, it's a nonprofit, it has to be deeded over, and
I
all those
understand that, but if
things.
it's not deeded over, we're not talking about the statute, we're talking about common use. They have a duty to come forward and say, listen, this is erroneous, because these lots are now, they're mere common areas.
If it's not deeded over?
If it's not deeded, so it doesn't qualify, and it's current use, current
Okay.
use.
I don't know that under the current scheme, there's anything they could say to change the valuation down to, again, something between the $500 and what it was assessed at baseline.
It's either one or the other.
Aren't you concerned that you have valued the same property for 2010 and 2011 as a common area, and but for one day, you've put a different valuation for 2009? Isn't that contrary to the whole purpose of the error correction statutes?
Well, two things. I'm not sure what you mean by the one day. We gave them 2010 because even though they were one day
They didn't
late.
deed it over to the HOA till July 1. If they'd done it on July 30th, it would have qualified under the common area designation.
It
isn't
qualified under either. Excuse me, Judge, but we're talking about 2009 and 2010. What's at issue here is 2009. The 2010 year we gave them, though it was one day late.
Okay.
2009 was a year and 1 day late.
You valued it 2010 and 2011 as a common area.
Correct.
What's your basis for, in terms of consistency, your directive to value this property consistently, to value it differently in 2009, knowing that you know now, and you've agreed that in 2010 and 2011 it has all the attributes of a common area? How are you consistently distinguishing its use in 2009?
It goes down to the statute. The statute is the exclusive method for identifying and valuing it, and that's the value it gets. Until they comply with those requirements, the assessor values it a different way.
Aren't you supposed to value it consistent with its use, what you know about its use?
And
Isn't that
again,
what
what I'm
you're-
trying to say is it has been. It was valued at its current use when the lot was sort of, before they started developing
The
it.
assessor did look at the plat maps and did, I mean,
Yes, unfortunately, if I haven't explained it right, I apologize. Okay, so you've got the common areas. There's only one way to distinguish is to just look at a map and see where everything is. So,
I mean, they obviously have different parcel numbers.
correct, and they do. And that's to keep track of what's the common area so that it doesn't increase in value as the buildable lots increase. Again, I have to keep going back to, it's a baseline value that's the entire dirt, let's say. That's the lowest value, marketable value that the assessor can give it until the statute is complied with. I guess I don't. The fact that it happened in
the taxpayer cannot challenge that lowest marketable value. Can't they come in with their own appraiser and say, even assuming, okay, you're saying the lowest marketable value is X.
Mm-hmm.
We say it's Y. We have an appraiser that we're going to obtain an appraiser that's going to say it was worth Y amount in 2009 for the 2009 tax year. Why can't the taxpayer put forth that argument?
I think that would be challenging it on a whole different level. This is alleging an error. Again, I have to go back to, this is an error that we didn't get common area status.
Sorry, my question was assuming that they've shown an error in the use, but you're saying, I mean, that's the threshold question, right? If they can't show an error in the use, they don't get to use the error correction statute. I mean, if you miss, unless they can show the assessor mischaracterized the use of the property.
Yes,
there
exactly.
There is no relief. There is
that's
no
what
relief.
and that's what we argued in our answering brief, is that you have to say, well, was the 0013 use code accurate? Did they look at this land and try to value it according to its current use? And that's what the assessor was trying to do, and that's how they value other subdivisions that are like this.
But if, I get back to my initial question, before it gets developed, you give it a certain use, and then as each lot, that's designated for, let's say, a home, gets developed, that increases. The assessor investigates that, sees it, raises the value.
Sure.
The areas that are common areas that never could be sold or never be used for actual development on that plain dirt, you're saying the assessor doesn't have to do anything. It can
They
just
don't,
keep it-
yeah, they don't also go down as the other buildable lots go up.
Right. But in this case, those were being assessed as if they were worth $12 million, right?
Well, that's the number
As opposed to plain dirt.
just, I happen to know the number that was 3.7 million square feet of common area. So the number is large, but yeah, it was being assessed at the value at the current use value, the market value, which is what it should be assessed at.
Current market value as if it were what? As if it were developable, or as if it were common area?
I think you have to look at it in terms of you're selling the whole subdivision. You're not selling this common area. Why would you sell the common area by itself?
But you wouldn't sell the common area at all. Once the subdivision's being developed and there are homes on it, no one's going to come in and say, the developer no longer can sell the entire subdivision.
That's
because
true.
they've sold off lots. The only thing they've got is a homeowners association.
Correct.
That may not have been deeded to it yet, but that it's being used as a common area. So why shouldn't if the assessor doesn't go back and say, oh, we misassessed the common area because it's being based on its current use, we've misassessed that, we should change this. Why shouldn't the a homeowner be able to come in on the error correction statute and said, you've erroneously assessed this?
Correct. And I've run out of time, but I have an answer for you before I sit down, which is, I believe because of the way the scheme is set up, it's presumed that as the developer, why would you not take advantage of the statutory valuation? It's the lowest value you can possibly get. It's right there for you. You have to have an HOA anyway. Just deed the property over, and then you get your low value. It seems very simple.
You're saying that even if it's being used as a common use, let me just make sure I understand it. Even if its current use is really as a non-marketable common area, you're not going to be able to develop it. You're not going to develop it anymore, or at least it's not going to be developed and marketed as if there was a home on it.
Correct.
Then, unless it's been deeded over, it just doesn't qualify.
Correct.
Okay.
Thank you.
I don't suppose I get the extra 5 minutes he had, but
No.
that's
You
fine.
may not need it.
I don't think I'll need it. Let me address a couple things really quickly. First, the complaint does allege this. Paragraph 4, the word moreover means in addition to, okay? I mean, it's alleged. It's very clearly alleged. It's alleged in the disclosure statement, paragraph 4. Very separate
word
paragraph.
alternatively would have been a better word.
Yeah, perhaps it would. In retrospect, maybe you should have said alternative. Maybe I should have pled it as different paragraphs. But at that point, all I knew when I filed the complaint was they've already agreed to this. They've already fixed it for 2 years. And by the way, let's correct a date problem. They weren't a day late. They were 6 months late for tax year 12 or tax year 11 because the date is January 1 of
the prior
2010, and it didn't record till July 1. For the prior year, the date would have been January 1, 09. We were 18 months late. The only difference between this case is we're now an additional 12, we're 30 months late. So it's okay to fix it 6 months late or 18 months late, but it's not okay to fix it 30 months late. That's absurd.
Well, I mean, why couldn't they do what they did? What presents them? I mean, the gift clause, or why couldn't they?
No, because
your
the whole
client,
point-
your
the-
client
The
did
whole-
well by that.
The whole point of, okay, that's the largesse of government argument. An honorable government would not keep money to which it is not entitled. Supreme Court of the State of Arizona, Pittsburgh and Midway Coal versus Arizona Department of Revenue. An honorable government wouldn't do what they did in this case. Now, I want to correct the record. You just heard a bunch of stuff that isn't accurate. They do not just value a big chunk of vacant land. The reason we know the assessor already knew about this is because they assigned individual tax parcel ID numbers to every lot. That happens the minute you record a subdivision plat. It goes to their mapping department, they put parcel numbers on it. At that point, they knew, because they had the plat, what were common areas, because they're identified as tracts. And the others are identified as lots.
Even if they didn't know.
They should have known.
They should have known. They had a
should
duty
have
to
known.
investigate.
And it was their duty because 13051 says the assessor shall, by diligent inquiry, ascertain. And 15054, the assessor shall make such investigation as is necessary. It's their duty. You don't shift it to me. Interestingly, why did I know about the PUC codes? When did I discover those? I discovered those by doing my own investigation once the case got filed. They didn't disclose that to me because I never got my file. I asked for it. I had to go dig it out myself. That's how I've discovered the PUC code issue, and that's why I raised it in my motion. This is the whole point of this error correction statute, when it was drafted, if you read the legislative intent language, was to fix mistakes when everybody agrees a mistake got made. Now, earlier I mentioned we did plead under the statute. One of the reasons we did that is because there's an affidavit on the summary judgment pleadings. You can read it. It's the affidavit of Mr. Thompson from Vista Verde, who said, we simply made a mistake. We didn't file the transfer of the deed. That's all that happened here. This is a classic mistake, and it's the sort of thing the error correction statute was designed to fix. And my last point is this. You cannot view this in a vacuum. There was 2 levels of administrative appeal that preceded this appeal. This case was presented on an error correction claim to the assessor, who fixed it for the first one, even though we were 6 months late. It was then appealed to the state board, and the assessor said, okay, you're 18 months late, we'll fix it again. Well, we're not going back to 09. So we filed the appeal to tax court as the procedure authorizes. That's where we are here today. That's the only reason we're here today, and we would request that the court consider that, and this idea that the use could change sometime in the future, I think is actually one of the more preposterous arguments that's ever been made, because they already know it didn't change, and they already agreed to fix it for those 2 subsequent years. So the idea that it could And the last point is, read 110014. It is the use at the time of the assessment that controls. Thank you.
We will thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. We will now take a recess to allow the attorneys to come forward and get prepared for the second oral argument.